AOL is a practitioner in this area, and he's agreed to answer any questions and share the industry view on this.
Great. You know, to be in here, maybe to answer this, Mr. Benjamin raises a very good point. Why shouldn't lawyers in Virginia, and I point out that Point Grace Conference is plaintiffs and defense lawyers, was formed, I guess, in the 1960s or 70s to advance the interests of efficiency in the civil justice system on a consensus basis between plaintiffs lawyers and defense lawyers. The question is this: for companies that do have minimum contacts, would satisfy the minimum contacts test in Virginia, why shouldn't we be able, as plaintiffs lawyers or defense lawyers, business lawyers or court lawyers, why shouldn't we be able to issue subpoenas to those companies that have availed themselves with the benefits of doing business in Virginia?
I think the significance of it, Mr. Chairman, is that what the model legislation did is strike a balance not only in regard to the due process interests of non-parties, and this is significant, these are non-parties, so it isn't as simple as the international shoe analysis where you say by virtue of your activities in the state and having availed yourself of contacts with the Commonwealth, you're subject to suit here. This is really a question of whether a third party or non-party is subject to the burdens of litigation in which they're not a party. So it's not just the due process issue, there's also a comedy issue between jurisdictions in regard to the breach of subpoena power. If I could sort of sketch out just a little bit of the background of this. This Uniform Act followed on a series of other model bills promulgated by the ULC dealing with this issue of how to conduct out-of-state discovery. I've been dealing with this issue for 20-some years in practice, 14 years in-house. In 2007, the ULC promulgated the Uniform Interstate Deposition and Discovery Act. Sets up a very easy process. Let me explain to you how it works. You simply go to the clerk's office. You go online, you look at the clerk's office, and where it is that your people or things are. You wish to do a subpoena, test a condom, subpoena to subpoena.
I'm sorry to interrupt you. Where the things are. Isn't that the rub? Because most of these things that we're talking about in this are, they're in the cloud.
Not always. So we're a pretty interesting case study in this regard. All of our consumer data is here in the 2 data centers that we operate here in the Commonwealth, every day. There are other companies that may have moved to, at least in part, to a cloud service solution through Amazon Web Services or somebody else. Even there, what you do is you go to where it is that the person is who can authenticate the records. In other words, who has access to the records. We're in an interesting spot because our data is here, but for example, many of our executives are in New York. So if you wish to depose our CEO, you go to New York, you investigate your subpoena there. New York has an apex rule. You have to sort of check the list before you inconvenience the CEO. All of that happens in Virginia with what the Model Act calls the discovery state. It makes sense if you think about that balance of burdens in regard to a non-party, that you would go where the people, where the things are. The substance of this matters. This isn't just a matter of convenience. The substance matters also. We have a number of jurisdictions that are going to follow California's lead. Inpatient in the wake of the student disclosures, they're passing their own ECHA legislation, which draws a higher burden for the type of process required to get discovery of a third-party communication or internet service provider. So again, the substance, if you deal with a California company that has a California choice of law provision in its terms of service, you would go and investigate in California, which is more solicitous to the privacy interests of those users than would be, for example, Alabama. So the balance is one that we worry about a lot. The burdens here on the third party we think are certainly worthy of consideration, and as Josh mentioned, we do worry a lot that this actually invites a lot of opportunism. This sort of riddle at the heart of the Yelp litigation is, why didn't he just do the form in California? It's easy enough. You don't have to hire a lawyer out there. You just do a form. You issue the form to the clerk's office. I think the short of it goes to the substance point I just made, which is California's John Doe statute is more solicitous of the privacy rights of an anonymous commenter than is Virginia's. It was as simple as that. That's the sort of real at the heart of the case.
Thank you.
afternoon. My name is Edward Mullen with the Reed Smith firm, and I'm here on behalf of the Virginia Chamber of Legal and Regulatory Reform Institute. I'll be very brief and just say that Virginia business is protected from the vagaries of foreign discovery law by the Uniform Act. And our concern is for Virginia-based businesses that making this change could invite changes in other states where other jurisdictions are reaching Virginia-based businesses in like manner. I certainly understand the convenience to a Virginia-based plaintiff and being able to serve a registered agent here in Virginia as opposed to going through the Uniform Act. Again, I think the long-term cost for Virginia businesses would be great. So, urge you to tweak the bill. Thank you for your consideration.
Mr. Chairman, my name is Guy Rolling, and I represent Google, and we wish to associate our position with the remarks of Mr. Novak. Thank you.
Thank you. Sir Stewart.
Mr. Chairman, I don't know if you can answer this, but does any other state follow the procedure that Senator Searle is seeking here in Virginia today?
Mr. Novak, you can answer that question from the back.
No. Whoever can answer. No. None. So we be the only state doing this? Would. Thank you.
Any other questions? Sir Stewart, you want to wrap this up?
Yeah, I mean, I haven't had a chance to research that question, but I find it hard to believe that you can't enforce an out-of-state subpoena in your own state, in any other state in the United States of America, but I'd have to go research that. But I'll tell you that the situation this creates, Justice Mims highlighted in his concurrence and dissent, which is that we could send out a subpoena for, say, bank statements or a check. A check that was negotiated in Virginia. Once it's deposited, it vanishes, it gets scanned, it lives on a server somewhere. We can send a subpoena to a bank that has 100 branches in Virginia, say, give me that check. The bank can come back and say, well, that document is stored on our server in North Carolina, and according to the Supreme Court of Virginia, it says you have to enforce the subpoena where the document's stored. So you got to go to North Carolina to get a bank statement, or get a bank check, or to get an email. Which to me is crazy when you have a company that's doing all kinds of business in Virginia, has all kinds of minimum contacts here, that does business here all the time. And so, you know, if this was such a radical proposal, I don't think the Boyd Grace Conference would have endorsed it after all the study and everything else after the bill was out here last year. I think it's a very common sense bill, and I don't think anybody's going to retaliate against us. Professor Bryson could probably articulate that better than me. He's been studying this for 40 years, but I think it's a very basic bill.
I should add that we've already done this in a specific area. In I think 2014, 2015, the General Assembly passed 19.2-10.2, which permits a prosecutor or an attorney general to issue a subpoena out of state for electronic communication service records for any company that's transacting any business within Virginia. So we're already doing that in that area.
Well, the bill's before us.
Move to report.
Motion to report, is there a second?
Second.
The bill's been moved and seconded. All in favor, signify by saying aye. All opposed?
No.
I think that the bill probably fails to report. Those are ayes to report. Aye. All right.
What was the point?
Three ayes. Three ayes, 9 nays.
4 ayes, 8 nays.
Got it. Thank you.
Thank you. Next bill, Senator Mason.
Sir, good morning, Mr. Chairman.
Senate Bill 1138.
I'll be a lot quicker than I was last time we talked about this. We spent a couple hours in the bowels of the building. I don't think there are any tornadoes in the area.
What is this now?
This bill today, in terms of
computer trespass, your personal iPad is treated just the same as a governmental iPad for computers. So this attempts to set up the penalty for computer trespass against local, state government, as well as state utilities, or public utilities, rather. Since we were here together last, Virginia Business has a cover story in August on protecting the grid, and the article does not say the sky's falling by any means, but Dominion Loan spending $500 million in the next 5 to 7 years to protect against it. And the 2015 Department of Homeland Security only behind manufacturing attacks against water, transportation, and government, energy, water, transportation, and governmental facilities, number 2, 4, 5, and 6, as far as cyber attack. So this was a recommendation from the Cybersecurity Commission a couple of years ago.
Anybody have any questions of the patron? Anybody wish to speak on this bill? Yes, ma'am.
Karen Jackson, Secretary of Technology. The administration is very supportive of this bill. We are pummeled by attacks on a daily basis. We have 4 every second against the Commonwealth state government network alone. So we were playing active defense every single solitary second of the day. We've also hosted a cyber and physical infrastructure conference back in the fall because we recognize that it's not just the ones and zeros that people are after anymore. It's actually going after SCADA systems and going after systems that control the lifeblood of life and living. We obviously had an election earlier this year. Both the Secretary of Public Safety and I spent an inordinate amount of time trying to make sure that these critical systems were as safe as possible. And we need to make sure that we have the penalties to back it up to make sure that we have some kind of deterrent in place to try to stave off some of these attacks.
Madam Secretary, no disrespect by asking this, but was this important enough for the governor to put money forward in his budget?
We were not, I'm going to just admit, we had a little bit of confusion on our side. We thought this had been dropped as a secretary's bill, which would have come with a budget amendment. It was only after our filing period was up that we realized that it was not a secretary's bill. However, I will commit to working with the governor to find the money should we make it out of it. Thank you.
Yes, sir.
Not prolong it, but to Mr. Chairman, Prime Secretary of Public Safety, just now punished as a misdemeanor, but raising it to felony would recognize the impact that the cybersecurity attack on one of our utilities could cause the Commonwealth. Cascading effects, both in impact to life and property. So I will endorse the bill and look forward to working with you to try to find that necessary $50,000 living minimum as the Commonwealth we can work together and make sure there's proper finance.
Mr. Chairman, Brittany Anderson on behalf of the Attorney General's Office and Ms. Bill.
Chair Michael Stack, Attorney for the City of Lynchburg, on behalf of the Virginia Association of College Attorneys, and we support this.
Senator Norman.
Mr. Chairman, I would move to report the bill to
Is there a second?
Mr. Chairman.
Discussion.
Mr. Chairman.
Yes.
I did have one technical suggestion.
Yes, sir.
That on line 33,
Thank you.
we replace the words while targeting with the words to the purpose of affecting.
If Senator Norman would be so kind as to withdraw his motion and push the amendment. The amendment's been moved and seconded. All in favor of this technical amendment, signify by saying aye. Aye. All opposed, the amendment's made. Senator Norman moves and Senator Stewart seconds. Motion report to refer. All in favor, signify by saying aye. Aye. All opposed, that bill is reported for your referred. Thank you very much.
Thank you, Mr.
I don't believe we have any other none on. Senator Howell.
Yes, and Mr. Chairman, Senator Reese has the same bill, so you can order.
Mr. Chair, on very well not that Senator Edwards is in the way of family emergency today, so his bill has
Well, just hold off on that. We may be able to do Mr. Senator Edwards a solid later, so. All right.
Thank you, Mr. Chairman. Senator Rees and I walked in this morning and discovered that we have identical bills. Mine is 1052, 1154 for Senator Rees. And as it turns out, we got the same bill through very significant channels, but quite different. Senator Rees serves on the Commonwealth, the Secure Commonwealth panel, and the Department of Homeland Security asked him to put it in. And my local Arlington County Police Detective Riley, who serves on the National Capital Task Force, also asked that the bill go in. So you have two versions, and I would ask that mine be rolled into Senator Rees.
Without objection, if we report these out, we'll roll these two bills together into Senator Rees and list you both as joint or chief co-patrons.
Thank you. And I have for everyone a fact sheet about what this is about, material support for terrorists.
Maybe just will distribute it. One of you wants to present the bill?
Sure. Thank you, Mr. Chairman. This bill basically provides that any person who provides material support or resources to an organization that's been designated by the U.S. Secretary of State as a foreign terrorist organization would be guilty of a Class 3 felony. If that such material support results in the death of any person, the penalty is increased to a Class 2 felony. The bill provides an exemption to those persons who provide such material support with the approval of the U.S. Secretary of State and the U.S. Attorney General. The bill provides that its provisions do not preclude prosecution under any other statute. What this bill is really designed to do is bring Virginia Code in line with federal code. It specifically defines an expert advice or assistance, material support or resources, personnel, and training. This came as a result of the incidents that happened in Northern Virginia. Why Corporal Riley's here today to speak to that, where 9 ISIS affiliates were arrested, and it just shows that we need clear laws in place to kind of counter these terrorists that are organizing in all 50 states now. So if you'd like to get a testimony of the fine corporal.
Yes, sir. Thank you very much for traveling down here. I appreciate your service and appreciate your assistance this morning.
Thank you, Mr. Chairman. Like I said, I'm detective with the Arlington County Police Department, currently assigned to Joint Terrorism Task Force with the Washington Field Office of the FBI. Our current primary responsibility in the task force is to combat violent extremists, essentially going after people who are looking to conduct attacks here or abroad, as well as those who support them. We currently operate under federal terrorism statutes, but due to the federal bureaucracy and a lot of other reasons outside of our control, our efforts are sometimes significantly slowed or pulled out halted and leaving our communities at risk. One benefit of the task force is that each federal, state, and local agency brings with them their local legal authorities to combat this threat. However, the way the current Virginia statute is written, we're unable to effectively go after suspected terrorists unless they've already attempted or already carried out an attack here in the Commonwealth. We're powerless to hold anybody accountable that supports a terrorist organization unless they break some other law. This amendment will give us the tools necessary to act in the event that the feds are too slow to act or refuse to do so altogether, while following the list of designated terrorist organizations by the federal authorities and State Department. The intention of this legislation is not to alleviate the federal government of their responsibility, but rather to provide us with another tool to collectively move forward while providing an independent backup option for the state and local authorities to act independently to protect our citizens if needed.
Thank you very much. Any questions?
Mr. Chairman, both Senator Howe and myself have submitted budget amendments and requests forward. Depending on what happens in finance, I think we would probably consider even doing an emergency clause if the monies were there to allow us to go through it on the House side.
Thank you very much. Senator Norman.
Mr. Chairman, it certainly raises a normal and good issue because it does create a class 2 misdemeanor. I think it's important for
It's been moved and seconded that bills be rolled together into Senator Reed's bill, that that Senator Reed and Senator Howe be listed as chief co-patrons, and that the bill be reported and re-referred to Finance Committee. Any discussion here? None. All in favor, signify by saying aye. Aye. All opposed? Thank you very much.
Thank you.
Senator Norman.
Thank you, Mr. Chairman. If I could direct the committee's attention to Senate Bill 874. Senate Bill 874 is a bill that has been brought to our attention by the Virginia State Bar with the concurrence and review of the Virginia Supreme Court. It is a bill that deals with the disciplinary system that has been established in the Commonwealth of Virginia. Currently, there is a rather antiquated and archaic provision with initiating bar complaints that it allows complaints to be filed with the Circuit Court or the Court of Appeals or the Supreme Court of Virginia. What makes this a little archaic is the fact that if those complaints are filed with either of those courts, ultimately it is referred directly to the Virginia State Bar for its investigation. So, Mr. Chairman, it deletes that language, and as we all know, that bar complaints are initiated by and to the Virginia State Bar that conducts the investigation. They're in a process that they still have the opportunity for judicial consideration because they can terminate the proceedings and ask for a hearing before a three-judge panel. I do have representatives from the Virginia State Bar and the president of the Virginia State Bar, Mr. Robinson, who was so glorious on the front of the recent Virginia Bar News. Do you want to say something?
We wanted to provide him with the opportunity to share some of his reflected glory with local lawyers up here. So, Mr. President, it's good to have you here.
Thank you, Mr. Chairman. I'm actually here only if the committee has questions, I would be happy to address them. Otherwise, Senator Norman has presented the bill and the reasons why we seek its passage.
All right. Thank you very much. Any member of the committee have any questions? Anybody else wish to speak in favor of this? Anybody wish to speak in opposition to this? Report. And it's been moved and seconded that this bill be reported, Senate Bill 874 be reported. All in favor, signify by saying aye. Aye. All opposed, the bill is reported. Thank you very much. What's the next? Senator Google.
Mr. Chairman, we'll just go in order and start with SB 796.
796.
Mr. Chairman, this was a bill that I introduced last year that favorable disposition in this committee is not a little bit challenged down the way. This is dealing with expungement for possession of alcohol and possession of marijuana, and it is limited to individuals less than 21 years of age, so it is very specifically, narrowly tailored expungement, and friends down the hall didn't see it quite the same way, but I'd love to take another shot.
As I recall, this fared very well in this chamber, and granted that it's difficulty down the hall. Does anybody wish to speak in favor of this bill? We have some familiarity with it. Anybody wish to speak in opposition to the bill? Yes, sir.
Mr. Chairman, Keenan Hook with the state police. It's just a fiscal impact with us. It's just a matter of allocating the resources we need for the personnel and technical changes to our system to accommodate the additional expungement we would expect.
Thank you.
Mr. Chairman, the governor's put multiple millions of dollars in for state police technology funding. I'm sure we'll be able to address his concerns appropriately.
All right. I move the bill be reported. It's been moved and properly seconded to report this bill. Any discussion? Hearing none, all in favor, signify by saying aye. Aye. All opposed?
Thank you, Mr. Chairman. Mr. Chairman, the next is Senate Bill 797.
797.
Mr. Chairman, this is one, and because of the year we're in, I'm concerned where it might lead us, but this came to me from a prosecutor who's had a challenge that doesn't happen very frequently, but where a competency evaluation comes back and there's a substantive disagreement about some of the conclusions drawn in the competency agreement, in the competency determination, and allows for there to be a request for a second evaluation or a second opinion on competency. So I think it's fairly limited in the scope, and I think it's even more limited in the potential application, but in the cases where it could have impact, it could be substantive.
Thank you very much. Members of this committee know this is a little bit outside the normal scope of my practice. So, Ms. Bench, do you have any thoughts about whether this reflects a substantive change in existing law, whether this can already be done?
Mr. Chairman, I'd be surprised if a court felt that it could not order another evaluation under existing law. There may be situations where courts say, without explicit authority, I can't do it, in which case that would be, I think, important for the committee to know. But otherwise, I would say that a court does retain the power to order any additional evaluations it seeks.
Mr. Chairman, the one example that I have, and I'm not as intimately familiar with the case, but it was out of Martinsville, and it was a murder prosecution where the defense hired a psychologist who came in with a report that said that the defendant was incompetent and the judge denied the request. Now, I do not have whether the judge denied the request because they specifically said they didn't have the authority. I can't answer that question specifically. And whether, and as we know, whether the court ruled that or not, I think this makes it clear that it could happen. Again, I think it's very limited in situations where it would happen.
This bill is designed to address that particular situation. I guess my question would be, I tend to agree with Mr. Benjamin that the judge already has authority to do this or party. But how does this bill actually change that situation?
Mr. Chairman, it would say that either party may move the court for an additional evaluation. So it doesn't say that the court is required to grant an additional evaluation, but it does make it explicit that either party may move. And so, given most of the cases contemplated, it would probably be the prosecution that was not pleased with a evaluation of incompetent. I don't know that many defendants who, where there was an evaluation that they were incompetent would be moving to have a second evaluation.
Any other questions? Vote for us. Anybody wish to speak in favor of an opposition to this bill? Vote for us.
Mr. Chairman, just in that, I think it probably has to be a finance if it is reported.
Right. Motion is for report regulatory finance. Any discussion? Hearing none, all in favor, signify by saying aye. Aye. All opposed? Bill is reported regulatory. Another?
Yes, Mr. Chairman, one other. And I have said the best last. I have a couple of individuals who really don't wish to speak this. Mr. Chairman, I will tell the committee, this is Senate Bill 1278. Mr. Chairman, committee may or may not be aware that the Sentencing Guidelines Commission, the way it was set up a number of years ago when it was set up, does a constant evaluation of sentencing guidelines. And on occasion, we'll come back with changes or alterations. Usually they're not more than one or two a particular year, and usually they're fairly minor at times. This is one that the Sentencing Guideline Commission came back. We directed the commission to go back and reevaluate this particular situation, and at the end of that, they decided to continue to move forward with their guidelines. The only way for us to alter the path of the Sentencing Guideline Commission's determination is to file legislation, and that's what we've done. So, Mr. Chairman, this is in reference to the guidelines for possession of child pornography. And you can see in the bill it does two things. One, it prescribes specifically what the guidelines would be for an individual who was found guilty of the offense and had no previous violent felony offenses. It would increase the midpoint by 100%. It would increase the midpoint of the sentencing guidelines, which are still discretionary, by 200% in cases where the defendant has been found guilty of a prior violent offense, with maximum punishment less than 40 years, and then increases by 40% if the defendant had been convicted of a prior violent offense greater than 40 years. So that would be the one item. And then the second item, if you flip over to section B, it would add in cases of child pornography violations. If the court imposed a sentence less than the midpoint, it would direct that the court had to specifically indicate that they had reviewed the evidence relating to what the defendant was possessing before rendering a sentence. So ensuring these are situations, Mr. Chairman, my years as a prosecutor, there are no cases that harm me more than dealing with individuals who abuse children, and these are the cases that I think are more serious than any of the others that come before the prosecutors. And this ensures that the court is reviewing the evidence that the defendant has possessed and really is the element of what is finding them guilty. So, Mr. Chairman, I understand that this bill would also have to go to Senate Finance if it was approved, but those are the major points. And that,
I do know that there are some significant issues with this bill that I think that the patron is committed to working on as it moves forward, if it moves forward through the process. Further ground to, and I think that you need to be cognizant of some of those concerns.
Mr. Chairman, one of those situations, and maybe it's not exclusively, is the cost, and so we are trying to work on that, and I think in dealing with that situation, we will have a alternate approach to dealing with the situation.
Senator Stewart.
One consideration, Mr. Chairman, for the committee is that regardless of how laudable a member might feel this is and justified, this would be the first instance in which the General Assembly has directed a sentencing court to do anything if it contemplates sentencing below a midpoint. Currently, if a judge is going to sentence below the sentencing guideline range, the sentencing judge must give a written explanation for that. But this would be the first time that we are requiring a sentencing judge to do something if it's going to sentence within the guidelines, but below the midpoint. And so a consideration for this committee, and it's always been a historical consideration when you have bills like this, is the risk of opening up the floodgates to similar provisions in other types of crimes.
Mr. Chairman, if that is a concern, certainly we could require that any sentencing court do that review before issuing a sentence, not just if they were contemplating reviewing below the midpoint. Certainly think these cases are serious enough that there should be no objection to requiring the court to review that evidence before making a determination of sentence in any case. I think that would alleviate Mr. Benjamin's concerns about opening the floodgates.
I kind of doubt it, but thanks for the offer.
Here you go.
I'm sure he thanks you for
Chairman, my name is Queen Cooper with the National Association to Protect Children. And first, I'd like to apologize to the Senate Courts Committee when I know I've worked with all of you for a decade, and you're pretty confident that I'm usually on my game when these child pornography issues come before your committee, and I simply missed this last year. The recommendations of the committee went into effect July 1. I think that Senator McDougal is going to be able to deal with the fiscal issue in his committee. There's a way I think that the bill can be rewritten that would address the fiscal impact without including enhancements. So I think that the reason the fiscal jumped up is because there were some additional enhancements included in the original language, and we're happy to just restore the guidelines to where they were June 30th. And with regards to Mr. Benjamin's concerns, that's not a deal breaker, for my organization. If you don't want to have the court review the evidence, although I think that for those judges that don't understand the gravity of this crime, it might be helpful for them, instead of just looking at a pre-sentencing report, they have to look at the actual crime scene images themselves, and that might help them understand the crime a little bit better. But if the committee's uncomfortable with that, we can live with that. Thank you.
Does that open the board to any consideration of an amendment?
Mr. Chairman, if it helps the process to continue to move forward, I'm very open. If it's not going to change outlooks, then I'm not as open.
Mr. Chairman, I'm going to report and we report the findings.
Wait a second. We're not quite there yet, if you don't mind. Let's hear from others. Mr. Doucette? Anybody in favor of the bill first? Yes, Mr. Doucette, sorry to stop you.
Mr. Chairman, Mike Doucette, I'm alternative to the city of Lynchburg, on behalf of the Virginia Association of Attorneys. I apologize first to Senator McDougal. We only had number of bills late Friday night, and I had an opportunity to contact him concerning our position on this. As Senator McDougal has pointed out, this bill is in two parts. The first part dealing with the amendment or the addition of the 17.1-805.1. We have no position on that as a policy decision by this particular body. That's, of course, the provision that would raise the midpoints in the ranges as far as the sentencing guidelines are concerned. Our concern and our opposition is the amendment to 19.2-298.01. First of all, this can be very, very unwieldy. When we have child porn cases, a lot of times there are hundreds of thousands of images, so we don't charge each and every single image just because there comes a saturation point where you're just not going to get any larger of a sentence. But there's going to be a burden that's created each and every one of those pictures, hundreds of thousands of pictures. So with this amendment to this particular code section, after whatever charge it is, and after charges there are, and the judge is convicted the defendant of these particular charges, is now going to have to be a separate hearing, whether it's before or after the judge pronounces sentence, as to whether or not the defendant also possessed these other uncharged photographs as well. And so we're going to have this sort of trifurcation of the proceedings. If it remains as, without the amendment, if it remains where it's after the judge has sort of decided what the sentence is, and he's decided the sentence is below the midpoint, we're now going to have this sort of a new hearing that's going to deal with the issue of these hundreds and thousands of photographs that were not charged and are not certainly before the court. And then there's also the question of whether or not there was any impact on plea agreements. Obviously, there's a plea agreement between the Commonwealth and the defense in these sort of cases. And it's below the midpoint. For whatever reason that we may have, then we're going to force the judge to look at all these hundreds and thousands of pictures of child porn. And then to do what? Because he's already sentenced. You can't re-sentence at that particular point in time. So our opposition is to the second point.
Good morning, Mr. Chairman, members of the committee. My name is Meredith Farrar Owens, and I'm with the Virginia Criminal Sentencing Commission. Because the Sentencing Commission is not a policy-making agency, it doesn't take official positions on legislation. By way of background, however, I would like to mention that the sentencing guidelines in Virginia, unlike many other states, are grounded in actual sentencing practices. In fact, the Sentencing Commission is statutorily mandated to develop and maintain sentencing guidelines that take into account actual historical sentencing data. In other words, the Sentencing Commission goes where the data takes us. In essence, the guidelines are designed to provide judges with a benchmark of the typical or average case outcome, given the defendant's offense and a prior record. I would like to submit to Mr. Chairman and the committee that as written, the bill may raise some proportionality issues. For example, the starting recommendation for a second or subsequent possession of child pornography, as proposed in the bill, would be greater than the starting recommendation for one count of production of child pornography or one count of aggravated sexual battery. Finally, the legislation would indeed set a precedent. The General Assembly has not enacted any legislation directing the Commission to modify the sentencing guidelines in any specific manner since the passage of sentencing reform legislation in 1994. And I would be happy to answer any questions the committee may have.
Any questions? Thank you very much. Yes, ma'am.
Ryan Dalton, Supreme Court Virginia Office of the Executive Secretary. We would just like to raise additional considerations for the committee to consider as to subpart B, which we have also raised with the patron, the constitutionality of requiring the judges to consider evidence of uncharged conduct and conduct that does not result in conviction. We don't bring an official position on this.
Thank you very much. Sarah Stewart.
Mr. Chairman, Senator Dool, based on what I've heard, would you consider a friendly amendment to lead the changes to 19.2-298.1? The second part of the bill.
Section, eliminate the changes in section B.
Right.
Yeah. I don't, if that's, can we move this forward? I don't agree with that.
What's your bill?
Yeah, I understand.
Well, and I don't think that we move that now. Take those sections out.
The motion has been made. Is there a second? Second. It's been moved and seconded. Any discussion? Hearing none, all in favor of that amendment, signify by saying aye. Aye. All opposed? Bills before us. If it's the pleasure of the committee, it needs to be referred to finance. Move to report for your second. It's been moved and seconded. All in favor, signify by saying aye. Aye. All opposed? No. Judge knows, please. Bill is reported and re-referred to the finance.
Thank you, Mr. Chairman.
Senator Sturtevant. Bill 833.
Yes, Mr. Chairman. Members of the committee, we have two bills this morning, both of which I understand it is the committee's pleasure will need to be referred to finance. Senate Bill 833 is in response to a number of the reports we've heard over the last years about individuals who have been convicted of relatively minor infractions, but who are unable to pay court costs and fines, and consequently lose their driver's license. So the idea behind this bill is to not require, but to give the discretion and the option to the courts around the Commonwealth to offer community service in lieu of monetary fines and costs to individuals who are convicted of non-jail offenses or offenses that do not require jail time as part of it.
I've got a very similar bill, but am I correct in my understanding that it is your intention to have this apply to two categories of folks, folks who are convicted of crimes but receive active incarceration, and second, people who are convicted of crimes but who
Judge.
but I didn't intend it.
And I understand that the chairman has a similar bill on this one, so.
In the courts where I practice, judges already do this. Is it your position that they can't have no authority to act right now, or?
I think this puts it in the code, makes it very clear that they do have the discretion, so there is no question.
Mr. Benjamin, maybe, the judge does not have the authority.
I can tell you that, from speaking to one of the board judges about this, I know that in my circuit, there is a disagreement about whether judges can do this during incarceration in the local jail. It says before and after. It doesn't say during. And I know that the sheriffs have some concern about whether it would impose a new burden on them, and I think we need to think about, talk about that, sheriffs need to have the resources to be able to do this, but Sheriff Sterling?
So that's the gist of the bill. I understand that there may be a fiscal impact that needs to be considered by fines.
We had a technical amendment to suggest, Mr. Chairman, on line 59, after the struck words, insert the sentence, if such person was incarcerated, work may be performed during the period of incarceration.
Before we take that up, I was educated as to certain terms of art within the correctional field. Is that incarceration, does that encompass local jails, or also does it encompass DOC facilities?
It's my understanding that the word imprisonment refers to DOC, and that incarceration is understood to be local facilities. I'm not confident that it's limited to local facilities, and so to achieve that, we would also add language that I think we use elsewhere in the code to the effect of if such person was incarcerated during the period of incarceration within a jail or local facility. Not rely on legislative services to duplicate the same language we use elsewhere. But that would specify that it has to be within the jail system, not within DOC.
So, with that, the technical amendment is there a motion to adopt the technical amendment?
So moved.
It's been moved. And seconded. All in favor of the amendment, signify by saying aye. Aye. All opposed. That amendment is adopted. Mr. Doucette.
Mr. Chairman, Mike Doucette, Commonwealth Clinic, Speaker Lynchburg, and actually, I'm not on behalf of the Commonwealth Clinic Association, we do not take a position on this particular bill. I'm speaking from my own personal experience. Certainly that technical amendment gives me a lot of relief as far as what the bill is going to do. Because the term of imprisonment meant folks who were in DOC. There's no question about that. The only other issue that I've got with even now with the technical amendment is the folks who are in the local facility who are going out and doing whether it's picking up trash or whatever it might be, they're getting credit towards their sentence already. They're getting a reduction to their sentence. And so this is going to basically not only give them a reduction to their sentence, but it's also could be used to alleviate their fines and costs. And my suggestion would be, for what it's worth, is basically add words, if no other considerations received. And that way they're either getting consideration as far as their sentence, a reduction of their sentence, or they're getting this being sort of credit towards the fines and costs, but not both. Because we have had situations where certainly there's been a motion for that. I mean, we're getting defeated, but there's been a motion in that direction.
Well, this is automatic, though, is that, doesn't the judge, it's permissive, says may, doesn't the judge make that determination when the judge makes a determination to apply the community service?
Mr. Chairman, I wish I could answer that question because I'm just not sure of how that credit is given.
Yeah, thank you. Mr. Jones.
Mr. Chairman, I'm John Jones, representing the sheriffs. While we don't disagree with the purpose of the bill, there may be some fiscal impact for the sheriffs if they have to supervise
sure that patron peace of mind is to make sure that it does not impose a requirement on sheriffs that don't have programs, facilities, or staff. So we need to make sure that we are cognizant of that. So any other questions?
Move to report be referred to consent items.
It would be my vote that you would be so gracious as to also include rolling my bill into yours. Yours, mine. All right, I'll second that. Thank you. So move to report and re-refer as amended the roll together bills and re-refer them to finance. So moved and seconded. All in favor, signify by saying aye. Aye. All opposed? Thank you.
Mr. Chairman, the second bill is Senate Bill 1090. This is another bill that may have a fiscal impact, and my understanding it is whether it should be referred to Senate Finance as well. It's a bill dealing with the use of ransomware in hacking. It adds new language to the code, making the use of ransomware, which is a type of malware that is used by hackers based on computers to deny access to the data on that computer. It makes that adding of ransomware to a computer classified felony. It also specifies that the statutes on computer invasion of privacy will apply to medical information as well. The reason for this bill is that we've had a huge increase in ransomware attacks, as we heard earlier today. And there are actually 4,000 daily ransomware attacks since the beginning of 2016. That's a 300% increase over 2015. And the entities that are singled out usually with these ransomware attacks are hospitals and healthcare providers. And hospitals are actually hit with 88% of the ransomware attacks. So the idea for this bill, the purpose of this bill is to make it a classified felony for any person to install or cause to be installed a computer program that will take control of that person's computer and the data on the computer. And as part of this ransomware process, money is then demanded in order to give control of that computer and that data back to its owner.
All right, so, and I apologize, refresh my recollection of this. With respect to hospitals and medical data, it would increase the penalty.
That's correct, to a classified felony.
All right. And you feel that this language is necessary to get to medical information, hospital computers?
I do, and there is someone who I think can speak on that, who is here, Mr. Strader, if you would like.
Those two questions that maybe your witness can address. Number one is whether the, what you're trying to get at is not already covered by A3, which says it shall be unlawful for any person with malicious intent to alter, disable, or excuse me, to cause the computer malfunction regardless of how long the malfunction persists. And second is, does this sufficiently constrain the definition of medical information?
Mr. Chairman, members of the committee, Matt Strader with Virginia Hospital and Healthcare Association. With regard to your first question, I must admit I'm not an attorney, so I would have to defer to the wisdom of the committee on that one. But we really have seen an increase